Now, judges in the High Court, you will be surprised to know how they are appointed in the High Courts. There is no law. Namaskar, this is Subhash Jha, and in the first episode of Nyay per Charcha, in English, we are going to have discussion and deliberation on judicial reform. For many years, there have been hue and cry in the country for judicial reforms, and not that suggestions have not been given by many like me in the past, but I'm certainly going to raise certain issues which possibly nobody in the country has ever raised. Coming back to how judges in the High Courts and Supreme Courts are appointed. Now, judges in the High Court, you will be surprised to know how they are appointed in the High Courts. There is no law. There is no law as to how a judge of a High Court could be appointed. Now, we are following what is known as Memorandum of Procedure. Now, there is a Memorandum of Procedure prepared based on which the judges are appointed for being elevated to the High Court and ultimately to the Supreme Court of India. Now, we are following 60-40 ratio. Now, 60% of the judges who are appointed as judges in the High Court of any High Court in the country are drawn from the bar, and whereas only 40% of them are drawn from the lower judiciary, that is by way of promotion. Now, that is the biggest problem with which, in my assessment, our judicial system is infected with. This is the biggest reason of all the ills with which our institution is infected with, and this has to be got rid of as soon as possible. Now, who appoints the judges? As per the standard procedure or memorandum of procedure, there is a collegium system. Now, collegium is comprising of the Chief Justice and two senior most judges of a particular High Court, which recommends the names of the candidates now drawn from the bar, and they are the ones whose names are then recommended to the Collegium of the Supreme Court. Now, the Supreme Court Collegium then, after having some deliberations or discussions, recommends these names to the President of to the Law Ministry, to the Government of India, and then the Law Ministry ultimately possibly has little choice then to recommend those names to the President of India, and then the President of India, upon signing off a warrant, a judge is then appointed as in the High Court. Now, you will be surprised to know that the highest court, any High Court of a particular state, is the highest court of that state. Now, whereas if a peon is to be appointed in any government office, now he is required to undergo some kind of a test. He is required to be assessed. His health, his height, his weight, etc. are required to be checked, and then only after going through the mandatory requirement of undergo test, possibly some interviews also, and then he is appointed as a judge, as a peon in any government office. But whereas you will be surprised to know that a judge in the High Court could be drawn from the members of the bar. Any practicing lawyer in the High Court in particular are drawn by what is known as collegium. These collegium then recommends the name. Now, don't ask me questions as to how these names are selected. That itself is shrouded in mystery, and something much more could be said about how these names are drawn. For example, now the Chief Justice, which is part of the collegium, is required to be necessarily from outside the state. Say a Chief Justice who takes over the office 2 months before or 3 months before or maybe a year before, and a big high court like Bombay or Uttar Pradesh, UP, that is Allahabad High Court, which has different benches. Can anyone expect that the Chief Justice of High Court, who has taken over the office and had remained in the office only for a period of 1 year, would know each and every lawyer whose names he would find it appropriate to be recommended? So the recommendation by the Collegium of the High Court itself is shrouded in mystery. And then these, what is the mechanism that the Supreme Court Collegium has to find out whether these names of all over the country? Now look here, now who forms the Collegium? The Chief Justice of India and 4 senior most judges. Now how these 4 or 5 judges, including the Chief Justice of India, is expected to have knowledge and information with regard to all the candidates all over the country whose names are recommended? In my assessment, zero. They have absolutely no knowledge or clue, or they're not required to have, because those are the lawyers who are practicing in the respective high courts, and those are not the lawyers who are practicing in the Supreme Court. So necessarily the Collegium will not know and will go by possibly their own assessment, and how these candidates are then assessed itself is shrouded in mystery. Now after the names are cleared by the Collegium of the High Court, sent to the Supreme Court Collegium, and the Supreme Court Collegium then recommends the name to the Government of India, and then finally the Government of India clears these names based on whatever information they have, either from our investigating agencies, who would then give clearance, and these names are then sent to the President of India. President of India then signs the warrant, and the candidates are required to take oath. Now the Supreme Court of India, a constitution bench, maybe in 88, somewhere in S.P. Gupta's case, if I mistake not, had set out as many as 11 parameters which a judge of the Supreme Court of a High Court is required to have. So unless and until though a judge, a candidate who is to be recommended by the Collegium for being appointed as a judge of the High Court, is required to have these 11 parameters. Now, but these parameters which the Supreme Court's constitution bench has said every candidate must possess, itself is gathering dust. Nobody bothers to see, check, find out whether the candidates whose names are being recommended by the Collegium, do they possess these qualities? Do they pass the parameters, these 11 parameters which have been laid down? And then the names, nobody bothers. Neither the Collegium of the High Court bothers, nor the Collegium of the Supreme Court bothers, nor the Government of India bothers. I have written several letters to Government of India that you stop those advocates whose names are being recommended for being elevated as judge of the High Court, if does not pass through these parameters as laid down in S.P. Gupta's case, then let those names be not cleared. You stall those names, but nothing happens. The government is possibly also under so much of pressure of the Supreme Court, thinking that if they do not toe the line of the Supreme Court Collegium, maybe they may have to face the consequences, because let us not forget the fact that the government, or any government for that matter, be it the state government or the central government, is the biggest litigant all over the country, be it any High Court or be it the Supreme Court of India. So therefore, possibly fearing that the Supreme Court may go against them, and it has happened, we have not seen, we have seen ourselves recently the Supreme Court frowning upon the Government of India or the Attorney General, saying that why the names recommended by us have not been cleared. And you'll be surprised to know that the names which have been cleared by those judges were part of the Collegium, and then the very judge sitting on the judicial side. So you take decision on the administrative side as an administrative judge, part of the Collegium, recommends the name, and then you try to sanctify it by your judicial order, by forcing the Government of India to clear those very names. So I had an occasion to write to the President of India, Prime Minister of India, the Law Minister, Vice President, Attorney General, everyone, that look here, a judge, I would refrain from naming the judge, but a judge who was part of the collegium, he recommends the name of certain candidates for being elevated as judges of different high courts. How can he be on the judicial side be taking a decision based on his own decision? So something which is against the basic tenet of law, that no person can be judge of his own cause, is what was being done. Fortunately, and I requested the Government of India to make a request to the Chief Justice of India and request him that either the judge should recuse himself or withdraw those matters from him. How can he be hearing the matter? And it so happened that just 1 week before, the concerned judge was to retire. The matters were removed possibly from his bench, and then a hue and cry as usual was made in the Supreme Court, and the Supreme Court judge concerned said that you do one thing, you take it, we can't do it, we have not done it, we have not directed the registry to remove the matters from our bench, but we do not know how these matters have disappeared. The only option which you have is to request to the Chief Justice of India to have the matter circulated. Now, incidentally, it so happened I was also waiting for my turn for mentioning some important matters, and it was the registry informed us at the 11th hour that no mentioning is allowed, and that is how nothing could happen, and the judge concerned retired. Now, this is what is happening with the collegium system. By virtue of 199th Amendment in the Constitution, Article 124A was brought to the Constitution. It was added to the Constitution by which, and this was done by it was a commendable job done by the Modi government as soon as it assumed office in the year 2014. Within 6 months of its assuming the office, it brought to the Constitution, or the Constitution was amended so as to include Article 124A, that is National Judicial Accountability Commission Act, Appointment Commission Act, NJAC, what is popularly known as. But within 6 months of it being added to the Constitution, and both the Houses of Parliament clearing NJAC, both Rajya Sabha and Lok Sabha, and this should have been the part of our system by which any High Court judge is to be appointed hereafter, as provided under Article 124A of the Constitution, was struck down surprisingly by a Constitution bench. Now, tell me one thing. Now, was it not, or could it not be that it was all engineered? Now, any matter which is filed before a bench of 2 or 3 judges in the Supreme Court. So, within 6 months of this act being added or being brought to the statute book, NJAC, it is not only a petition is filed, the petition is also heard by 2 or 3 judges bench. Then it is recommended that it would be appropriate that let the matter be heard by a Constitution bench, and within 6 months a long order which runs into several pages are rendered by a Constitution bench, and NJAC Act is struck down. Now, on the ground that it is unconstitutional. So an act which is brought to the statute book, passed by both the Houses of Parliament, Rajya Sabha as well as Lok Sabha, is unconstitutional. And what is known as Memorandum of Procedure for Appointment of Judges is constitutional. What a joke it is. But this is what is happening. The Supreme Court, unfortunately, our government in the past have been so weak that they did not realize the danger of encroachment on their rights by the judiciary. Now, what is the function of our courts? The function of our court is only to interpret law and not to create law. But what the Supreme Court in the past 2 to 3 decades have been doing is to enact law as if it is their function. It is not your function, my lords. It is the function of the lawmakers, the legislature. You are only part of three. There are three. It is said that there are three pillars of democracy: legislature, executive, and judiciary. You are only one part of that system, whole system, or the pillar. And then it is expected that nobody would be encroaching upon anybody's functioning. This is also, in my assessment, is a flawed idea. Parliament, as per our parliamentary system, is the supreme, because they are the one who makes the law. Who makes the law? So far as the Central Act is concerned, it is made by the Parliament. And if Parliament makes the law, which the judges are expected to interpret or enforce the law. Now, who should be supreme? Obviously, the Parliament should be supreme, because no judge could be appointed unless until the President of India gives you an oath. And who gives? The President of India obviously doesn't function. It functions on the advice of the Council of Ministers. So, this is something which has been happening in this country, that in the name of writing judgments, in the name of interpreting the law, the Supreme Court or even the High Courts have been legislating, which is certainly not their function. Now, this is one part of how in our country we have been, our Supreme Court or the High Courts have been functioning. Now, don't forget that these very judges who are recommended by a thoroughly flawed system of appointment by what is known as a collegium. Now, collegium, in my assessment, is nothing but a group of judges who have encroached upon the rights of our legislature. Something which is required to be done by the Parliament, by the lawmakers, you usurp those powers and you start functioning as if you are the lawmakers. You are not the lawmakers, but you have become the law unto yourself. Now coming back to the next issue. Now this is one part of the flawed system of appointment of our judicial officers, and more particularly the judicial officers of the High Court. And these very judges who are appointed in the High Courts, respective High Courts, then find their places in the Supreme Court, because these are the judges who are ultimately elevated to the Supreme Court of India. Now this is one part. Now the second part I am going to deal with in episode 2. And here I take a pause. Thank you very much for hearing the part 1 of the first episode of Nyay Pe Charcha in English by Subhash Jha. Thank you.